Hi, I'm Brian Heidelberger, a partner with the law firm of Winston & Strawn in Chicago, and here today with another mini advertising law lesson. Today's law lesson, what brands and agencies need to think about when they're doing trademark clearance. But first, let's dip into our mailbag. I got an email recently. It says, okay, Brian, we get it. You know a thing or two about the law. Isn't there anybody else at that firm who knows anything? Well, thank you so much, Dad, for the support. There is actually other people here who do, and today I'm going to share with you my colleague Mary Catherine Colback, who's going to walk us through what brands and agencies do need to worry about when they're doing trademark clearance and what they might not think about. So, Mary Catherine, what's the biggest thing that brands and agencies seem to miss when they're doing trademark clearance?
The biggest thing that agencies and advertisers miss when they're conducting trademark clearance together is the attorney-client privilege. Agencies are coming up with taglines, the brands are ultimately adopting them. In this process, when the parties are working together, they want to share legal information with one another. If the parties aren't careful, they could accidentally waive the attorney-client privilege, and this can really come back to haunt you in the event that there's a lawsuit.
Tell me, how is this issue implicated for a brand?
Brands will charge their agencies to come up with taglines. The agencies then will ask their in-house counsel or their outside counsel to conduct trademark clearance, whether it be a preliminary search or a preliminary and a comprehensive search of that tagline. The agencies then sometimes will forward on the correspondence that the attorney came up with to the brand, or the brand will request it from the agency. So, in the event that the attorney correspondence that they send to the agency, which then gets forwarded onto the brand, includes some references to something that could be, high risk for use of the mark, but the agency ultimately uses the mark, then arguably that correspondence is going to be discoverable in the event that there's a lawsuit.
And what about an agency? How is it implicated for them?
Sometimes the agency is responsible for indemnifying its client for trademark claims for the trademark clearance it conducts. If the agency shares its own legal opinion regarding the trademark clearance to its client, and there's some sort of problem that results from the mark where there's a lawsuit, then the agency is not only indemnifying the client, but the correspondence from its attorney could be discoverable.
So, Mary Catherine, tell me, generally, what's the law here that we're talking about?
The case law on this topic is sparse, but there's not a lot of support for the proposition that agencies and brands working close together protects the attorney-client privilege.
So, Mary Catherine, now that we know the background, what's the most important thing for both brands and agencies to keep in mind on this issue?
First, take a look at your master services agreement between the agency and the brand. Who is responsible for trademark clearance? Depending on who is responsible, the party that is responsible should be the one that's taking special attention to making sure that the attorney-client privilege is maintained. Number 2, audit your practices. What is exchanging hands and by whom? If you're the brand, you want to see what the agency is providing you with and whether this is something that your team has been requesting of the agency or whether it's something that the agency has simply been providing. If you're the agency, you want to understand what your junior account team is sending to the client. Number 3, have a conversation between the legal teams of the agency and brand. There's no one-size-fits-all strategy to make sure that the attorney-client privilege is maintained, but we think that it's in the best interest of both parties to try to ensure that the privilege is maintained. Last but not least, train the teams to make sure they understand what can be shared and to whom. This is particularly important for agencies who have junior account teams doing trademark clearance. In efforts to make the client happy, they may share more information than they should.
So, I hope that information was helpful. Thank you to my colleague Mary Catherine Colback for helping out today. And until next time, let's be careful out there.